Good afternoon, Commission members, staff and members of the public. In opening today's meeting, I wish to make a brief statement. This afternoon's meeting of the Commission is to determine a request by the State Administrative Tribunal that the Commission reconsider aspects of the approval granted to an application considered a significant development under Part 17 of the Planning and Development Act 2005 on the 16th of May 2024. A major premise of Part 17 of the legislation is that it bestows upon the Commission a perceived unlimited level of discretion with respect to an application. As with any planning application, the Commission has the option to approve the application, defer determination pending further information, or refuse the application. This is a considerable responsibility which the Commission takes very seriously. I wish to advise observers that the Commission members may refer to technical advices such as phones and laptops throughout the meeting system in considering the information before them. This meeting is being recorded and will be available for viewing on the Commission's website and YouTube channel. On behalf of the Commission, the Department of Planning, Lands and Heritage will respond to any media inquiries relating to this application or process in consultation with the Minister for Planning's office. Okay, that was a mouthful. In opening the meeting, I acknowledge that we are meeting today on the lands of the Whadjuk people of the Noongar Nation and pay my respects to elders past, present and emerging. We have a number of commissioners attending in person and a number online. Myself, Deputy Chairperson Heron, obviously here in person, Commissioners Bennett, Sandry and Shears here in person. Commissioners Adair, Hall and Brooks are online, and I note that Commissioner Hall does need to leave by 3 p.m. In terms of observers, I don't believe we have any, no. And we have apologies and leaves of absence for Commissioner Cole and for Commissioner Lakey. In terms of disclosures of interest, there are two, and they are both impartialities. One is from Commissioner Shears, being a perceived impartiality interest, and it's on the basis Commissioner Shears has advised that she knows the applicant. In terms of Belinda Morich, is known to her and her family. We have reviewed and agreed that there is nothing impeding her ability to make a decision in relation to that. We've also just identified that Commissioner Bennett was an employee of the town during some of the correspondence in question and has identified an impartiality interest, and given it was back in 2001, we are very comfortable that there is no inability to make independent decision making. So that brings us to declarations of due consideration. And in relation to this, can I specifically cite an email that was sent this morning to all commissioners, which included attachments associated with previous correspondence from Belinda Morich, and have reviewed that information. Can I confirm online that, just give me a nod that you have received and reviewed? Yes, thank you. And then we'll do the overall declaration of due consideration. Can I ask that all members indicate that they have given due consideration to all the items contained in the agenda? Thank you. Deputations and presentations. Over to you, Sam.
Good afternoon, everyone. Welcome to those to make a deputation this afternoon. Our first deputation today is from David Vinicum from the town of Claremont. Look to the table. Thanks, David. You're welcome to deliver your deputation when you're ready. Thank you.
Chair. The town considers that in accepting the new information presented by the applicant on past cash and move payments, that new parking standards of town centre infrastructure plan should be considered also as new relevant information. These standards require the provision of 112 bays for this proposal, and after taking into account previous cash and lieu contributions in the parking provision, the total parking shortfall is between 56 and 59 bays. That would attract a contribution for cash and lieu of over $1 million. If parking licences are to be considered as cash and lieu bays, noting that this is not supported as I'm referencing below, then the parking requirement would be reduced to 33 to 36 bays, resulting in a cash in lieu contribution of $643,500 and $702,000. The proposed condition reducing the cash in lieu payment to $154,250 will place a burden on the town to supply the parking shortfall, which is just short of $1 million, for the development of future parking facilities in the town centre at a cost which will ultimately fall back onto the town's ratepayers. Alternatively, an unfunded shortfall may reduce the town's capacity to provide adequate parking facilities to support business in the town centre. Therefore, the town would prefer that the proposed condition be refused and that the matter then be referred to a full state administrative tribunal hearing where all relevant information can be considered as a hearing de novo case, inclusive of the new parking requirements established in the town centre plan. It is, however, acknowledged that the Part 17 process and the timing of this approval predated the town centre parking requirements. Actually allows to vary these requirements for the development. Accordingly, the recommended compromised position acknowledging full cash in lieu payment for 11 bays and the monetary value of 23 parking licences can be accepted as a basis for the revised condition, although, as previously stated, this is not preferred. It's important to acknowledge that the parking licences were established as a temporary measure in the 2010s to support business growth in the town centre following the development of the Claremont Quarter development and Baby Terrace dying. At that time, the scheme provisions required the contribution of land as part of the cash in lieu payments, and that added over $100,000 to each of those cash in lieu bays. The licences were applied as a deferred parking contribution, which were retrospectively and legally acknowledged under clause 33(3) of the scheme through Amendment 123, which was gazetted in January 2017. Noting that these licence payments were accepted in good faith by the applicant at the time to support their applications, along with 9 other applications between 2012 and 2014, which totalled 40 licence bays. It is not considered appropriate that the full cash in lieu value be applied to those 23 bays under this application. The cash in lieu clause 33 requirements have not been reconciled in relation to this or previous applications that were determined during that period. And provision actually requires that the applicants trigger that. Depending on the outcome of this decision, and the SAC case generally, it would be open for the town to consider pursuing a debt for the licence base. In this context, the proposed compromise condition will have an influence on where this matter lands and is considered reasonable to support the development with the compromise condition. And at this point, I suppose, until this matter is determined, council won't have the chance to consider that. But I must say, we do want to support this application. We see it as an important development for the town centre. And again, we consider the condition a reasonable compromise.
Thank you. Does anyone have any questions? Yes.
Chair. Thanks for the presentation, David. Your position is very clear in that as a town. Can I ask around expenditure of cash in lieu funds that have been received over time and what records? I understand there are limitations to the town's records around this, but what records you do have around expenditure of funds and the parking facilities that may have been constructed. And then the second part to that would be, does the town have a strategic plan for future expenditure of funds?
From what I can tell, and I've only been there since 2012, there is around this or over $500,000 in the cash in lieu fund. What has been spent is we have 2 parcels of land, Lure Avenue and on Claremont Crescent and Shenton Road, where public parking is constructed, as well as there's constructed bays up along Davies Road, north of the intersection with Shenton Road. So there is, all that with me, there is probably well over 200 bays, 250 bays in those 3 parking locations. We've also developed some car parking bays in relation to our typical site and, done public parking plans in relation to that. The town is building up its funds, and as a result of the planning regulation requirement for us to have a payment in lieu of parking plan, we have adopted a payment in lieu of parking plan, and that identifies through the costings that we have a number of sites in the town centre. We have the rear of the council building, above the car parking bays that are there. We can add another couple of decks of parking there. We have a deck proposal that we could consider in the Davies Road car park. We could consider the corner of Claremont Crescent and Shenton Road as another deck car parking space. The preference is not to. There is land in Lure Avenue that can have some decking of parking, which is accommodated again under the town centre plan for some widening requirements to get a feasible design outcome to that, which respects the amenity of the residents. And the final one is a site on the southwestern corner of the showgrounds, where there have been proposals for a 7-storey parking station, and the parking plan sort of indicates that we could possibly do a joint venture with the RAS for a parking station there, and that is within, I think, it's within certainly the walkable distance of the town centre. So it would accommodate staff parking requirements for the town centre.
Thank you very much. That answers my question.
Commissioner Hall, I did see your hand up. Did you have a question?
Thank you, Deputy Chair. My question was the same as Commissioner Bennett's. Thank you.
Thank you. Are there any further questions? Yes.
Thank you, David, for the presentation. I'm just back to the licenses and the condition that was put on the 2013 and 2014 approvals. I guess that approach to taking cash in lieu with that conditioning, that specific conditioning, is that something the town does regularly?
So, thank you for the question. No, it was a special consideration where we worked out that the Bayview Terrace was going to die. We couldn't change uses. Amendment 123 was proposed to consider concessions on parking, so you could get up to 35% concession to modernise those requirements. It took into account what we called bays which had already been accommodated. So if because Bayview Terrace was a town centre or a street, the term, sorry, getting out of the terminology in my semi-retirement. Because it was a main street which was developed in the 1920s, there wasn't a lot of parking for vehicles, forced parking in the street. So there were, as a result of that, we considered a status quo situation where if a sale was a shop, we considered the modern parking standards and we deducted those from the additional variations that took place. The scheme amendment provided for the town to take into account a policy which we adopted, and at that time we knew that we had the land holdings for the bays, so it was going to be a deck car parking situation. So $30,000 a bay at that point, and the town also acknowledged that certain uses it wanted to encourage in the town centre, so it reduced those preferred uses to $15,000. So we've been very conscious of being able to support business in the town centre during that period, and I suppose we just don't think it is fair play for a cash in lieu licence or a licence to be taken as full cash in lieu payment for this base.
Just one more question following on from that, if I can. In relation to the advice note, then I guess that sort of explained that to some extent. What, I guess, discussions then was had? I mean, that advice note, I understand, flagged the potential for more contributions at some point in the future. Since the 2013 and 14 approvals, were there any discussions with the proponent or the owner of the site as to what that might look like in the future?
In the process of this application, we've been constantly reviewing calculations. We haven't gone back to them or any other landowners in terms of reconciling the cash in lieu licenses. As I said, it would be open for council to do that. I don't think they would because, again, as I said earlier, we want to encourage this type of development, and it has always been our approach to be fair in the way cash in lieu payments are imposed.
Ms. Andrew, did you?
Yeah, thank you. Thank you through the chair. Thank you for your deputation. So just to clarify, just at the Town of Claremont's parking plan, probably the area that's in proximity to the subject site would be the council's own land, in which it says that parking opportunities exist there. Where is that in terms of the town's forward capital works plan?
One of the projects that I'm undertaking for the town at the moment is a review of that strategy and getting valuations for all the work, getting design done, and so that council can then make a decision on moving forward. We have 18,000 allocated to that in this year's budget, and we're progressing along those lines. It's not something that can be just done out of thin air.
Thank you. And just one other question, sorry. Is there any are there any planned car parking improvements as part of the town's forward capital works plan over the next 10 years?
We probably have, well, we haven't done a 10-year plan for those capital works for a start, but coming out of my paper that I'm writing is a discussion paper for the town. It's currently at about 25 pages. It will give council guidance for that capital works program and where the first parking bay should be like parking station should be located.
I just want to clarify, sorry.
Sure.
Through the chair. And so there's no dispute that $165,000 has been paid. Okay. And there's no dispute that there was a payment of $11,250 paid in 2014.
That was for the
License.
License, yes.
Yeah. And was there another payment? I'm just trying to get my head around it. Undertaken in 2015 of $49,000. Is that correct? 2015, I think the payment was made in relation to a 2014.
$1,250 in September 13 and 49,000, correct.
Great, thank you.
And just one final question from Delph, unless it was online. No, just one final question. I'm wanting to be clear. So there is a specific fund which is holding the money from cash in lieu. Can I just confirm, is that also interest accruing, or does the interest get?
It would be interest accruing, yes.
Okay, thank you. So I've just come across situations before where the interest goes into other locations, but thank you for that clarification, and thank you very much for your submission.
Sit in front of signs and just
Wherever you're comfortable.
Thank you, Deputy Chair and members of the Commission. You've received a copy of my letter that formed part of the agenda. Also included in the agenda was a previous letter prepared as a final component of the mediation process. Unfortunately, that version of the letter that found its way onto your agenda did not have all of the attachments included. A matter that I realised this morning when I was preparing for today. So
Can clarify. So that was what I was, and so I did confirm prior to that everyone has received it and reviewed that.
thank you very much. I don't intend rereading what has already been provided to you, but I need to highlight several points and perhaps to rebut some of the things that have been mentioned by Mr. Vinicum for the town of Claremont. We're not here to seek a reconsideration of the calculation of the way in which these bays have been assessed. The development application was forensically assessed previously in May. And while I was not involved in that process, my understanding that a large part of the condition setting of that, from reading the minutes, did relate to the appropriate methodology to use for the calculation of bays. The effect of those discussions was a condition which reflects the fact that there is a shortfall of 22 bays in this circumstance. And on that basis, the condition has been drafted to require a $429,000 payment to the town of Claremont. I should let you know that at the time that this development application was considered, it was not clear how many bays had been paid for by my client. That arose after the fact, once some documents were found looking at where it was clear that at least 11 bays, the 1999 payment had been made. Unfortunately, our discussions with the town were unfruitful, and that led to a Freedom of Information application that forensically went through all of the documents that were still available after the town of Claremont's fire a few years ago. And a large ream of paper was provided to us, which included all of these additional payments that had been made. Our firm position is that it is not open in relation to the payments that have been made to characterise them as licence payments. At the time, the development approval is a document that includes conditions precedent. At the time that those conditions were imposed, clause 33 of the scheme was in place, which gave power for the requirement for cash in lieu in circumstances where car bays could not be provided. And in respect of each of the approvals in 1999, 2013, and then again in 2014, each of those conditions makes express reference to clause 33 of the scheme, as it then was drafted, and a copy of that wording is at paragraph 11 of the letter that you received this morning and forms part of your agenda. So notwithstanding the commentary made by the town in relation to those documents, it's clear on the face of the scheme of the approval itself that clause 33 was invoked. Clause 33 says that you can pay money in lieu of a bay, and that was undertaken. It should also be noted that in relation to two of those approvals, there's actually no reference to licence in the condition of approval itself. So in relation to the approval granted in 1999, and then to the approval granted in 2014, one was for 11 bays and one was for 14 bays, so 25 bays in total. There is actually no reference in the conditions of approval itself relating to licence at all. In the 2014 approval, there is a reference in the advice notes, but of course they have no legal effect. The way that the recommendation has been put to the Commission this afternoon has been to essentially provide a hybrid solution to this to this issue, and we say that we would caution the Commission in taking that position in relation to this matter, but in terms of its potential impact and precedent it creates for the Commission and for local governments moving forward. And I say that with the greatest respect, but there is a new position statement that has been issued by the Commission in the last little while. I think it came into effect at the end of last year. And one of the things that it does is it provides a certificate in the back of the guidelines that local governments are required to give to landowners when cash in lieu has been paid. Now that is essentially a recognition of a development right. It says that in relation to this land, you have paid for bays that you can't see but are to be taken into account in any assessment of a development application. By going behind the number of bays and recalculating in the way that the recommendation suggests, I think is a dangerous situation to get to. And in any event, I think it's an unfair way of going about it as well. When you look at the amounts that have been paid in relation to these sites, and bearing in mind the shortfall arises because of essentially like for like, there are tenants who are in there at the moment who will be leaving for the redevelopment and will be coming back. So they've already paid, their bays have already been paid for those. But if you look at just a simple CPI calculation of the costs of those bays over time, I mean, $15,000 in 1999, I plugged it into the very simplistic Reserve Bank of Australia calculator, CPI calculator. $15,000 in 1999 is $30,400 today. All up, when that calculation is undertaken in relation to all of the bays that have been paid for, we're already at $393,000 in today's values. Again, we don't suggest that approach is taken. A bay that is being paid for in cash in lieu should be identified as a bay to the assessment of the application. And it's on that basis that we say, in this circumstance, given payment has been made in relation to many more than 22 bays, that this condition 30 should be removed. Thank you.
Any questions? Yes.
Thank you. Through the chair, I just want to clarify. So we were provided the additional documents this morning. There was a table that was provided titled Summary of Payments Made for Capital of Car Park.
Yes.
It just states that the total paid is 35. I wanted to confirm if that's intended to be 34.
Oh, yes, it should be 34. My
Thank you. No, that's okay.
apologies.
Just
Yes,
wanted
yes.
for the record, that was all. And I'll just go through the same process as I did with the previous deputy. So I just want to confirm that the suggestion is that $165,000 was paid in 1999
Yes.
and 11,250 was paid in 2013
Yes.
and 49,000 was paid in 2014.
Yes, I should preface that it was paid in respect of the approvals granted. So it may well have been that the actual payments were made slightly later. Yes. Yeah.
Understood. No, that's fine. And then I just have a question just in relation to the conditions regarding these licenses. So that correctly, condition speaks to being able to essentially request future payment. You can call to request future payment
Yes.
because it's a license. Just in your opinion, can you actually have a condition or an advice on a DA that seeks for a future payment that hasn't been explicitly detailed?
I think, based upon, the case law in Randall and the town of Vincent is a good start, is that you can't have a condition that is uncertain. And say in this case, certainly if the condition itself required something to paid at some unspecified amount to be paid at some unspecified time, then certainly that would be an uncertain condition. Having said that, it's not even in the condition, it's in the advice notes. So it's almost a flag to the fact that they were intending to attempt to have some form of retrospectivity to their planning framework at some point. That never arose. There was an amendment made to the town of Claremont's planning scheme, but it certainly didn't have retrospective power.
Thank you. And sorry, through the chair, something that you haven't touched on is the Claremont Town Centre Precinct Structure Plan. How do you see that the Commission should consider that as part of it?
Well, I mean, this this application was considered before that structure plan became effective, as I understand it. That's right, Nathan.
So it had gone through SPC with conditional approval about a month before our application formally came through to the Commission for assessment. So when we lodged our initial intent to lodge Form 17A back in October 22, all parking assessments were based on the town scheme, and that's the line that was taken with the Department Planning's officers through the process, right up until the very latter part when the draft structure plan was getting crossed to a conditional approval. That was then wasn't communicated to us, but it appeared on the WAPC agenda that that document had been used to calculate parking.
And so what I should add to that is that the fact of those planning standards, of those car parking standards was flagged in the agenda that came to the Commission in May last year. And from reading the minutes of the meeting, that appears to have been why there had been a number of different methodologies proposed for the calculation of car parking because of this imminent planning framework coming into effect. Having said that, the Commission at that point was not minded to apply those rates. And I should say that the Commission since that point has not applied those rates. There was a reconsideration of car parking in respect of another development on St Quentin Avenue at the end of last year that the Commission looked at and didn't apply those rates in that circumstance either.
We do have the benefit of actually having one of the people who was present at that meeting who might be able to shed light on that. But any further questions?
I do, not on that particular matter, but I do have a question, Deputy Chair. Thank you for the presentation and the background information. I appreciate that and the additional information that was provided this morning. Can I ask a couple of questions? The visitor parking, the 14 bays that are there, the officer's report, which you would have seen, talks about the fact that those are comprised also of ACROB bays. There's reciprocal parking arrangements, there's use for hire car within those. What would be, or to what extent do you see those 14 bays as being compromised for ready use by the proposal and occupants of the proposal or visitors?
So I believe that there was a discussion when the application was considered by the Commission, there was a discussion about those bays being transferred to reciprocal bays. At the time, they were being treated, as you say, specifically as visitor bays. I believe it was agreed by the applicant that we were able and willing to consider them as reciprocal bays that could be used for not just visitors, but for commercial uses during the day, and a bit more flexibility in how they'd be allocated.
Yes, yes. I understand too that a number of them, I'm just trying to find the number now, but a number of them are also ACROD bays, so they're not actually able to be used readily by any person accessing the development.
I believe there was 8 non-ACROD bays
That's
to be used.
okay, of the 14. Thank you. And then an additional question. So the comments in the report around on kind of page 11 of the report talk around that we can't consider a direct like for like consideration of car parking, so that bays that were paid for previously are not equivalent to the bays that are required now for a number of reasons. One of those reasons, and I'd be interested in your view, Belinda, is that there's an increasing intensity of land use, such as a land use which is a hotel that wasn't previously contemplated. Cash in lieu wasn't previously paid for that sort of use.
I actually don't entirely understand the reasoning in that, the reason that's been given there. I mean, unless there was a circumstance where a different cash in lieu value was assigned to different types of land uses, you might then say, well, these cash in lieu bays were provided for shops, and what's now being proposed is not a shop, it's a consulting room or a hotel. But it actually doesn't make any sense. I mean, a bay is a bay. You're
Perhaps I can
providing-
assist, because I think that the premise is, as was being discussed previously, is that a main street setting where it was reconfiguration of shops was treated in a particular way. This is actually adding a hotel, a multi-story component, which is of greater intensity. And again, we can get on, we're not going to enter the debate now, but just to help that clarifies, I think, the assertion.
And sorry, whereabouts does this appear on page 11 of the report? I can reread it just so I can.
Dot point list. Yes. And it says, beginning of the dot point list, it is not considered in this instance, however, that a direct like-for-like deduction of paid for car parking days from the assessed shortfall is appropriate given. And there's a number of points there in that list. And the second point down talks about the Deputy Chair's comments around the intensity of the proposal and including new land uses.
The number of bays that the Commission has said we are in deficit for is 22. And so it's not clear to me how those bays could be
That's okay.
differently applied in
I don't need any more than that, but I just wanted to understand your own view on those points that were in that list. So no, thank you.
And Belinda, if I can ask, in terms of, I mean, your calculation with the CPI component, point taken, but the rate of 1,250 per bay as a cash in lieu contribution, would you accept that that would be considered to be very low calculation?
Well, it might be, except for the fact that it looks like it was already paid for previously in 1999 over the same piece of land. So
No, I'm not calling it. I'm sorry. The question is, would you consider that to be a reasonable cash in lieu contribution?
it depends what the policy for the local government said at the time. It may well be that in some local governments that was appropriate because what they were putting in was, car parking meters for, to meter
Sure.
existing, roadside car parking. It sounds like the current proposal for the town is to provide, major parking infrastructure, and it may well be that at the time that wasn't intended.
Sure. And can I clarify, was the contributions and nature of them contested at any point?
Not that I'm aware of it. They've all been paid. So,
Yes, so sorry, that was what I was trying to get at. So that was paid openly, and at no point was that questioned or contested. Okay, thank you. Are there any other questions? Thank you very much for your deputation. Okay, we will now move to presentation of key issues, and Ryan, over to you.
Thank you, Deputy Chair. Good afternoon, Commission. As we've heard today, the decision under review relates to the Commission's May 2024 decision to approve the partial demolition of existing commercial buildings and construction of a new 8-storey mixed-use development at lots 5 and 11, lots 12 and 14, lots 2 and lots 5 and 6, Bayview Terrace, Claremont. The development comprises 8 stories, 12 retail tenancies, including a shop, restaurant and small bar, as well as a hotel and apartment uses. From a parking standpoint, the development provides for 63 residential bays, 16 on-site bays comprising reciprocal visitor and hotel car bays, as well as Acrod bays, 5 motorcycle bays, 53 bike bays, including visitor bicycle bays. In June 2024, the applicant applied to the SAT seeking a review of Condition 30. This requires a cash in lieu payment of $429,000. And as outlined in the May 2024 meeting minutes, the amount payable was derived from the determined parking shortfall, 22 bays. As we've heard today, the applicant is seeking a review of Condition 30 for it to be deleted on the grounds that they contend previous cash in lieu payments received by the town of Claremont between 1999 and 2014 must be taken into account in determining the potential shortfall. Having regard to these previous payments in respect to the subject land, the applicant contends that there is no basis to impose Condition 30 in instances where payments have been received in lieu of car parking bays. They are not contesting the determined parking shortfall of 22 bays. Before addressing the points raised earlier, I will first turn to the application's background and context, which are important factors to consider. Since the application's original determination in the mid-2024, the Town of Claremont's Town Centre Precinct Plan was approved in September 2024 by the WAPC under delegation. This plan established a new commercial car parking ratio of 1 bay per 48 square metres, effectively doubling the parking rates when compared to that applied to this application, which was a ratio of 1 bay per 100 square metres. This figure was derived from the then commissioned draft interim guidance for non-residential car parking. Following this, in October 2024, the WAPC determined a separate Section 31 SAT reconsideration for a nearby mixed-use development at Lot 50 St Quintins Avenue, Claremont. Similarly, this Part 17 decision included a review of car parking standards within the Claremont Town Centre Precinct Plan, and on the general grounds of consistency of decision-making and economic impacts linked to the Part 17 provisions, the WAPC maintained the 1 bay per 100 square metre ratio, even in light of the town's framework. Fast forward to November 2024, saw the Commission's non-residential car parking rates published, which maintained the 1 bay per 100 square metre parking ratio, but included additional scope for local variations where demonstrated through technical information. As we all know, in determining Part 17 applications such as this, the Commission is not bound or restricted by any legal instrument, including local planning schemes and or policies. However, it must have regard to the purpose and intent of any planning scheme that applies, the need to ensure for orderly and proper planning, the need to facilitate development in response to economic effects of COVID-19, as well as any relevant state planning policy or policy relevant to the Commission. The Commission is also to ensure that the condition is valid. As a general test for a condition to be valid, it must be for a planning purpose, it must not be unreasonable, and must fairly and reasonably relate to the proposal. Having regard to these points, it is open and indeed appropriate for the Commission to exercise its discretion and reconsider Condition 30, having regard to the new information. In this regard, it is accepted that the applicant has previously paid for cash in lieu in accordance with development approvals. Historical development approvals. The historical records confirm this. Taking this into account, whether the condition is deleted or the amount owing reduced is a matter for the Commission to determine based on merits. As we've heard today, both cases are arguable. As outlined in the officer's report, historical records from the town of Claremont confirm that between 1999 and 2014, the landowner has contributed $225,200 towards in cash in lieu payments linked to previous development approvals of the subject land. These same records indicate a total parking shortfall of 34 bays. Recognising the new information, the town supports consideration of historical cash in lieu payments in the review of Condition 30. In presenting these two options, the town favours reconsidering the condition altogether in light of its updated framework. This would see the parking shortfall rate effectively doubled, raising to some $1 million. As outlined in the officer's report, this approach is not favoured on the grounds of consistency of decision-making as well as Part 7 economic considerations. The town's alternative approach supports reducing the cash in lieu amount to $154,250, which varies the total amount payment by deducting 11 bays and a sum reduction of $60,250 for the parking licences. In arriving at this recommendation, the officer's report concludes that a direct like-for-like deduction of the previous sum of $225,250 is too simplistic. Factors considered include the passage of time between the development approvals, changes to the planning framework, historical concessions granted by the town as documented, and because of the complete redevelopment of the subject land. We'll not go into further details at this stage, but I'm open for questions on that, as outlined in or detailed in the officer's report. With all things considered, the hybrid approach is instead recommended, which deducts the full 11 bays from the shortfall, as well as previous financial contributions made by the landowner in the form of licence payments. This results in a payment of $154,250, which is a meaningful reduction of some $274,750. The officer's report also includes commentary on deleting the condition altogether. Now, if I may turn back to the, material we've heard just then, I've got a few, observations to make. We're certainly agreeing with the applicant that historical payments should be honoured. However, there is no express provision in the scheme or planning legislation that required historical payments to be completely discounted. We also respectfully disagree with the assertion that a cash in lieu payment is a right that somehow attaches to a property. In this respect, I draw the Commission to a public open space analogy. Unlike the provision of public open space, which is calculated from the gross subdivisible area of a lot, cash in lieu contribution for car parking is derived from a parking need tied to a bespoke land use activity. Inevitably, like the planning framework, parking need is likely to change over time depending on the intensity of the use and broader planning context. These factors are not static. Further, any claim that a decision to amend the condition as proposed would be invalid due to, a legislative intent or explicit intent is eroded by the context of Part 17. As we've heard, the Commission has discretion in its decision making. Notwithstanding this, and at the risk of repeating myself, we do agree that with the applicant that historical payments are important and should be considered. In this regard, the Office's recommendation has regard to case law, which broadly outlines the importance of taking previous payments into account in decision making. Put differently, ignoring previous payments altogether is likely to deem any reconsideration or condition unreasonable. This is not the case. The proposed approach balances a multitude of factors and is considered justified and reasonable in the circumstances.
Thank you. Questions for Ryan?
Yes.
Thank you, Deputy Chair. And thank you for the presentation, Ryan. And just following on from the question earlier that I had for the applicant in terms of the change in the land use and the intensification, that goes to your point. I just want to draw this out a little bit more. That goes to your point around you're of the view that parking is not a static thing and that it can demand and requirement can change over time, and therefore it's not permanently attached to the land, that it should be reviewed as development applications are put forward on a piece of land.
Certainly, Commissioner Bennett, especially in this case where it is a redevelopment of the site. And again, drawing attention back to the hotel use and some of the other comments received. Looking, obviously, this is new information. She did not have the benefit of having this as part of the original decision. Certainly not looking to kind of relitigate that decision, but I guess looking at the parking provided on site, it was still, I guess, deemed that a shortfall 22 was required and was in fact considered appropriate in light of the intensity of use. Obviously, looking at it now, we've still got a case where the parking itself is fairly restricted in nature. Yes, we understand that there has been some historical payments, but there still is clearly a use and an intensity there that needs to be addressed somehow.
Thank you, Ryan.
Any other questions for Ryan? Just a couple from me. It was obviously, I think you did touch on this. It was the suggestion in terms of the caution to the Commission in relation to taking a hybrid approach. I'm just wanting to get your perspective in terms of, do you see, I mean, as I understand it, at least there is, full discretion available under the Part 17. Would you see there being an issue around precedent that could be applied that we need to be mindful of?
Thank you, Deputy Chair. Certainly precedence is something that needs to be considered. In this case, it is a Part 17 application, so naturally it is, I can coin the term, ring fence to Part 17 applications. Certainly in this case, we feel that it's a pragmatic outcome, it's reasonable. If I can highlight on that, it's reasonable in the context of the testability of a condition. We are honouring previous deductions. Again, factoring in that there needs to be a multitude of different factors considered in arriving at, I guess, what is reasonable. We're not here to litigate or question the previous payments. We agree that ultimately the applicant did receive clearance from the city or the town. Facts do speak to the fact that they were granted a number of concessions along the way. That needs to all be taken into account.
Thank you. No other questions? Thank you very much. Well, with that, we will move to the item at hand, item 4.1. And there is a recommendation. If I could first of all have a mover and seconder for the recommendation. there any foreshadowed recommendations? Oh, sorry, Commissioner Hall.
Thank you, Chair. Yes, I'd like to move a motion to delete condition 30.
Is there a seconder for that motion? Thank you. Commissioner Bennett. Did you wish to speak to that, Commissioner Hall?
Yes, please. Thank you. So, look, I really support the development, and that includes the feasibility of the development. It's well located next to a train station. It's in a town centre. It's going to go a long way to helping the housing challenge that the state is facing. There has been significant previous contributions made to the town for cash in lieu for car parking, and the town currently does not have a clear plan on how they're going to use any further money. So for that reason, I propose that, or I move that we delete condition 30. Thank you.
Anyone else wishing to speak to the matter?
Sorry.
Please.
Thank you, Deputy Chair. I'd agree, just to clarify around the car parking calculations, I'd agree with the original car parking assessment of the 22 bay shortfall. To more than double this under the town's PSP would be shifting the goalposts through the assessment and consideration process. The nature of the proposal has not changed in any way, and therefore I don't feel like it's justified to go back and revisit the car parking requirements. The information that we've been presented today was not available at the time that the original decision was made. So in taking into account that additional information, I do recognise that the town has concerns with the provision of car in the town centre, and that there are future redevelopment opportunities that exist. But based on the information presented today and in the reports, and having considered that, I'm of the view that the cash in lieu funds and the licence funds that have been paid today, which do not appear to be in dispute, are sufficient to cover the payment of bays that's greater than the 22 bay shortfall.
Sorry, Commissioner Sandria, then Commissioner Adair.
Thank you. I too will be supporting the motion. I think as heard from both deputies and the department, there's no dispute over the fact that 34 car bays have been paid, and that shortfall has been paid regardless of the amounts. That contribution has been made for 34 car bays. I also echo that the 22 car bay shortfall is the appropriate calculation to take for this application. One, that's what it was considered as part of, and secondly, the WAPC has also used that 1 bay per 100 square metres in October of last year as well. So it's important that we remain consistent through our decision making, particularly through the amendment process, which is not uncommon as things evolve through building, etc. And I do, and for those reasons, I'll be.
Commissioner Adair.
Thank you, Chair. I also will be supporting the motion that's being put forward. I have a slightly philosophical position, I suppose, in that if there's a reduced number of bays that have been identified, in this case 22, without the council, the city, the town having a position for a solution in regard to how they're going to spend those funds to actually make up the fall, you remain with the same problem. So I don't believe that the town has identified that it is actually going to solve the problem by taking this kind of money. I also agree with Commissioner Sandry in that our position was made quite clear last year when the St Quintin Avenue application was in front of us. We have an existing approval. This is a reconsideration of one condition. So I'm not going to revisit the whole application by applying something that's changed in the framework during that or post approval. Thanks.
Well, I think before I put the motion, I would say that I understand the position taken, and I do in fact rely upon those who may have more background context than myself in terms of the considerations that were held at the time when it was considered. I do concur that the notion of applying the new framework would not be appropriate. That being said, I do also see the merit that was presented in trying to find pragmatic middle ground. But I think in the context of what's been presented, we clearly have a position here. So the motion that is currently before us is to delete condition 30. We have a mover and a seconder. Is there any? Yes.
But can I just ask a question just to clarify for the purposes of the minutes? Is it in fact the case that you are dealing with, well, in my view, I think you're dealing with an alternate recommendation?
Yes.
As proposed by Commissioner Hall. So in that case, the minutes would reflect that the officer recommendation lapsed and Commissioner Hall's recommendation replaces that. Sorry, just to clarify for the minute.
Thank you very much.
Ask another question later.
Certainly.
Because you are required under legislation to give reasons for decisions, so you will need a reason for the alternate. And then obviously, because this is a section 31 reconsider, make the reason for, you know,
That was provided by the mover.
Yeah, so that's why it's sort. Yeah. So so the reason I think has been articulated, and we do have that on record. So are you suggesting that that needs to be further articulated, or?
No, I'm just clarifying because it's a slightly different situation to, I think, what we've had previously, where so we just need to make sure we get the minutes correct, because otherwise the records won't actually reflect your decision. And
I had hoped to get a move in a second and then let it lapse, but you know, there wasn't anyone prepared to do
No,
that. That's fine.
Yeah, just as long as to clarify we're all on the same page, because otherwise it's difficult to produce the minutes.
Okay, understood. We're all clear? Okay. Is there any dissent to the motion? Okay, what's the appropriate terminology? The first motion has lapsed, and so the alternative motion is now present. And any dissent? If not, we'll take that as carried. And thank the officers for the efforts in presenting the information today. And we then move to item 5, which is State Administrative Tribunal applications. There's 2, one being renewable energy facility, being a wind farm, and the second being lot 1001 Claysbrook Road, Perth.
So then, is there any update on either of those? Ask at the last meeting.
Still in that application.
So no, there's no further information for us to consider.
In terms of
Or information.
that reviews in general. And
No, those 2 that are listed on the
no,
agenda.
that was it. Thank you.
No worries, thank you. Is there any urgent or other business? No, thank you very much. I'll declare the meeting closed at 3 o'clock, just on time for Commissioner Hall to dash off as required. Thank you very much.